This is good legislation worked out over a long period of time, and a lot of thoughtful work went into it on both sides.
Today I rise in enormous opposition to H.R. 6304 because, frankly, Madam Speaker, it's very difficult to put lipstick on a pig. And what we have here is the opportunity for the government to conduct mass untargeted surveillance of all communications coming into and out of the United States without any individual review and without any finding of wrongdoing. What Americans don't know is that this government can now surveil you for 7 days without any approval. And then if the court denies the application, while the application is being appealed from the denial, you can be surveilled for 60 days. This is not constitutional protections.
Madam Speaker, as some say on radio, now let's hear the rest of the story. After the arguments just made on this floor, this is actually a great day. We and the American people have been waiting for this since 12:01 a.m. on February 6th, when the Protect America Act expired. During the intervening time, we've actually been unnecessarily vulnerable to those who would do us harm in this era of worldwide terrorism.
Because what this bill does today is reaffirm what we have been saying for the last several years, that the due process of the Constitution, the Fourth Amendment, is alive and well and protected in this bill.
This government can now surveil you for 7 days.
And any rhetoric to the contrary is simply not true.
This bill undermines the ability of federal courts to review the legality of domestic surveillance programs.
It's fear-mongering.
It provides de facto retroactive immunity to telecom companies.
For any of the U.S. citizens who believe that their phones are going to be unceremoniously and unjudiciously tapped or listened to is simply wrong.
You can be surveilled for 60 days.
And this bill reaffirms the importance of that Fourth Amendment.
Unfortunately, the negotiators who brought this bill to the floor bought into the flawed assumptions of the Bush administration that because we live in a dangerous world, we must now redefine the Fourth Amendment, and thus the fundamental relationship between the government and its people. If this bill becomes law, it will perhaps be the only lasting legacy of the Bush-Cheney administration's overhaul of national security policy, a congressionally blessed distortion of congressional checks and balances. It permits massive warrantless surveillance in the absence of any standard for defining how communications of innocent Americans will be protected, a fishing expedition approach to intelligence collection that we know will not make Americans more safe.
They'd prefer operating under an outdated law that makes it impossible to move with the speed and agility we need to have to protect the country in an age of terrorism.
In this era of worldwide terrorism,
jihadist terrorism,
the fight against terrorism, wherever it may exist.
Madam Speaker, I rise in opposition to this bill. I appreciate that some improvements have been made to Title I of the bill, but even these improvements are undercut by the scheme in Title II that means there will be no accountability and perhaps no adherence to the provisions of Title I. I cannot support the legislation's deeply flawed provisions relating to the issue of immunity for telecommunications companies. These provisions turn the judiciary into the administration's rubber stamp. The review provided for in this bill is an empty formality that will lead to a preordained conclusion, dismissing all cases with no examination on their merits. Under this bill, the courts are not allowed to ask whether the conduct of the corporations who assisted was in fact legal. They may only note that the administration says that it was legal. In other words, the decision on the ultimate question of legality, a decision the Constitution dedicates to the judiciary, will instead be made by the executive branch, with the judiciary acting as a rubber stamp. It turns the process of judicial review into a joke and denigrates a supposedly independent and co-equal branch of government.
I'd like to point out that the grant of retroactive immunity to the telecoms is inconsistent with our basic principles, because we are breaking with a very proud tradition of intervening for the first time in a pending court decision in an effort to reach a preordained legal outcome.
This bill says if the telecommunication companies violated America's privacy willfully, knowingly, knowing it was illegal, we are giving them immunity. Where is the excuse for that?
In order to uphold the principle of the rule of law and the supremacy of the Constitution, we must reject this bill.
Where is the excuse for turning a nation of laws into a nation that will be led by a president who knows how to manipulate our fears?
The bill is a fig leaf granting blanket immunity to the telecom companies for possibly illegal acts without allowing the courts to consider the facts or the law. It denies people whose rights were violated their fair day in court, and it denies the American people their right to have the actions of this administration subjected to fair and independent scrutiny.
Under this bill, large corporations and big government can work together to violate the United States Constitution, use massive databases to spy, to wiretap, to invade the privacy of the American people. There's no requirement for the government to seek a warrant for any intercepted communication that includes a U.S. citizen, as long as the program in general is directed towards foreign targets. This Congress must not allow the names of innocent U.S. citizens to be placed on secret intelligence lists. Under this bill, violations of Fourth Amendment rights and blanket wiretaps will be permissible for the next 4 years. Massive and untargeted collection of communications will continue.
As Judge Walker put it in the AT&T case, quote, AT&T's alleged actions here violate the constitutional rights clearly established in the Keith decision. Moreover, because the very action in question has previously been held unlawful, AT&T cannot seriously contend that a reasonable entity in its position could have believed that the alleged domestic dragnet was legal. Close quote.
Those companies have not lived up to a standard expected by the American people. They come out of this, I don't think today is any cause for celebration for them. They come out of this with a taint.
Furthermore, it allows the type of surveillance to be applied to all communications entering and exiting the United States. These blanket wiretaps make it impossible to know whose calls are being intercepted by the National Security Agency. Let's stand up for the Fourth Amendment.
The bill actually permits the government to perform mass, untargeted surveillance of any and all conversations believed to be coming into and out of the United States without any individualized finding and without a requirement that wrongdoing is believed to be involved at all.
You can be surveilled for 60 days.
First and foremost, the proposal before us ensures that we will continue to have the ability to monitor the conversations of Al-Qaeda.
Others, including myself, had their privacy invaded even though they posed absolutely no threat to national security.
America's at war. We have to do all we can to protect our nation from those who seek to harm this country, our communities, and our families.
You know, America cannot afford to have a pre-9/11 mentality when it comes to our national security.
And those on this side have accused us of having a pre-9/11 mentality. Let me remind them that July 4th, 1776 was pre-9/11. And heaven help us, the day that those values are shucked aside at the service of fear, reject this bill.
Let's remember when this country was founded, Benjamin Franklin said, those who would give up their essential liberties to achieve a measure of security deserve neither.
Gentleman's time is
Vote
expired.
against it.
But the yeas are 293, the nays are 129. The bill is passed. Without objection, a motion to reconsider is laid upon a table.